Hi, good morning everyone. I am Prasida here, head of the Department of Nanotechnology at Nish Kanyakumari. Here at the Department of Nanotechnology Nish, we offer a quality education through research with external funding sources from DST, DBT, DRDO, ISRO, etc.
So, thank you, madam, for the introduction of the department as well as myself. So, good morning to everyone. So, hope I am audible to everyone. So, let's begin with the presentation. So, am I audible to everyone? Can someone reply?
Yes, sir. Yes,
Yeah,
sir.
okay. Thank you. Thank you. So, today we'll be see about the intellectual property rights and how it is done in India. So, we are specifically looking into the IPR related to Indian patenting system because the patenting rights varies with countries to countries. So, what is intellectual property? So, we all know land documents. Okay. So, that is an asset based document which is registered to a particular person so that he can get the complete ownership of that land. The same thing is applied to this intellectual property also. So, here what happens, any product or a process which comes out of the intellect of a person which should be protected, so that only the inventor or the person who has the idea or who made the product will get benefited out of this product. So, that is the main idea behind this intellectual property rights. So, here you can see what happens is a person who hold the IPR or the intellectual property rights will get the whole ownership of the product, so that no other person is entitled to use the product without getting permission of the owner of the product. So, if someone is found to be using the product, what he can do is he can legally approach the court or the authorities and stop the other person from using the product, as well as he can also get royalty or damages for the damage the other person has created. So, this is the main basis of the intellectual property rights. So, when you are looking into the scenario of the world, so we will see some statistics first, then we will go into the actual patenting its types. So, when you look into this chart, Here what you can see is this is the data provided by the World Intellectual Property Organization. So, the total number of patents applied by different countries. So, although India is in the top 10 positions, but when you look into the status of this China, they have published around 18 lakh or 16 lakh patents in 1 year. But whereas when we look into the scenario of India, we have applied only 77,000 patents in a year. That is around in 2022. When you look into the status of the total grant, so when 18 lakh patents are applied, not all the patents will be granted. So some rejections will happen. There will be a less number of sanctions will be there based on the criteria. So when you look into the scenario, China, their grant is around 7,98,000 patents has been granted, and whereas for us it is only 30,490. So when you look into the grant percentage, China, they have a grant percentage of around 75%, and India there is around only 39%. So the number of patents what we are applying is also less. The same thing, the number of sanctioned patents which is getting granted every year in India is also less. But when you look into the scenario, like 5 years back, we have a total applied patents of around 50,000 in 2018, and now we have a in 2022 more than 77,000 patents has been applied. So this scenario has to improve. If this scenario is improved, what happen? More products will be developed from our country, and there will be a huge boost to our economy. So this is one of the main reason, because China is the world leader in product manufacturing, because of the number of patents they have in their hand. So because of these patents, they have the technology to produce most of the products. So when you look into the number of patents in force, so what happens is patent has a lifetime. So all the products goes to expiry. The same way patents also has some expiry. So in the year 2022, when they looked into the scenario, the number of patents in force, that is the number of active patents, if you look, in China they stand in number 1. They have around 42 lakh patents or active patents. The next comes the United States, then come the China, and we are in the 18th position. So only because of this, when you look into the economy or the GDP of the countries, all these countries 1, 2, 3, that is China, USA and the Japan, they are the highest GDP producing countries. So that is also because of the number of patents they hold, or the number of active patents they have in their countries. This is one of the main reason for their boost in the economy. So next, if you see in India, if you see, the number of patents are increasing, but when we look into the world scenario, the numbers are very, very less. So there should be an awareness among the public that patents are very much needed for product manufacturing. Only that will give a sole proprietorship or a ownership over the product, so that there will not be any competition in the market. So patents are very much needed. So why patents? So far we have seen the scenario of the countries. So when we look into the largest countries in the world, so we have this Microsoft corporation. So they make products like laptops also. Now they are making this Surface laptops are there, as well as they make products like software products. Windows operating system is there, Office is there, Power BI is there for data analysis. So when you look into the number of patents they hold, they have around 1,27,000 patents. This is one of the reason, because they are being the market leader in their segment. So next we have this Google Incorporation. So this is having around 52,000 patents. Maybe you may ask a question like, Microsoft is having 1,27,000 and Google is having only 52,000. So what happened is, like some 3-4 years back, Google merged its company. So Google Incorporation is also there, Alphabet Incorporation is also there. Alphabet also comes under this Google Incorporation. So there is also another set of patents that comes under this Alphabet. So that is not included. So that's why the less in number. So we know this Massachusetts Institute of Technology, which is one of the topmost universities in the world, they hold around 13,000 patents. Then we have this TCS, that is the Tata Consultancy Services, they have around 7,000 patents. Then why I want to stress this ASML? So we all know chip manufacturing. But in order to make chips, equipments are required. ASML is the only one company in the world they make these equipments for chip manufacturing. There is no other companies or no other companies have the required technology to make integrated circuits. ASML is the only company in the world they make equipments for chip manufacturing. They are kind of a monopoly company. No one is there to compete with them only because of the number of patents they are holding. They are holding around 31,886 patents only in the areas of integrated circuit manufacturing. Then we have this Samsung. They are one of the largest patent holders. They have more than 7 lakh patents in their portfolio. So next, when we see, we are seeing into only the patents filed by Indian companies. So when you look here, we have this CSIR labs. This is a collective of all the CSIR labs in India. They have a patent portfolio of more than 2000 patents. Then we have the Bharat Heavy Electricals Limited. They have a patent around 2000 patents. Then have this TCS, TVS Motors, Tata Steel, Tata Motors are there, Wipro, ITC. All the companies who are into production or to develop some process, they rely mainly on the patent to protect their products or their process. So these patents are very, very important or essential component if you are going for manufacturing or production or sale of any other product. So this is the scenario of the patents in Indian companies. So next thing we have seeing only about the companies. So next, if you see the patent filed by Indian universities, if you see that scenario, there is a university known as Lovely Professional University. They have more than 2000 patents in their portfolio. Next comes this Chandigarh University, then have this IIT Bombay, IIT Madras is there, Amity University, then something known as Chandigarh group of colleges are there. So these are some of the, I am not telling other colleges are not having any patents. All the colleges are having some sort of patents in less numbers or more numbers, but these colleges are the largest number of patent filers in all over India. So all this information is provided by this WIPO. So this is statistics is from the year 2016 to 2022. So when you look into the actual IPR scenario, patents are the intellectual properties classified as given here. It is classified into patent, design, trademark, geographical indicators, copyrights, and semiconductor integrated layout design. So semiconductor layout design is a new thing to our country. So the number of designs applied in India is very, very less. So because most of the semiconductors are manufacturing happens in foreign countries, and we are bringing the product into India as a whole manufactured product. So now only our country or our government has taken necessary steps so that we will be starting our chip manufacturing plants in another 2 to 3 years. So when you look into the scenario, all the IPRs are having an increasing trend. So like patents, if you see 2017-18, we had around 47,000, and now we are applying around 66,000 patents. So everything we are having an increasing trend, but this should double in numbers in the coming years. So then only we will have a monopoly in most of the fields. So because of all this, if you look, our country is also growing at a higher rate than other countries in the world. Another one more reason in order to speaking this growth is India is having the largest youth population. Youth population means the people around 10 to 24 years. These are the people who have more number of ideas, and they can provide great wealth or intellectual to the country. So India is doing good in terms of this global competitive index. So India is now at 40, and we are also high in the global innovation index. When you look into the scenario, in 2015 we were in 81st place, and now we have moved to the 40th place. That is, this is the statistics of this 2023. So that is all about the introduction and why we should concentrate more on intellectual property. So now we will go into the real theme of this webinar. We will see about the types of IP, what are these, and how to apply, how to write these things also we will see a little by little. So when you look into the classification of this intellectual property, uh, first we have this trademarks, then we have this industrial design, we have copyright, geographical indications, we have semiconductor circuit layout design, trade secrets are there, then plant varieties are there, then we have this patents also. So when you look into this trademarks as you can see, so trademarks are nothing but the logo the companies uses. Because when we look somewhere, we don't read the products, we just look at the symbol and we tell, oh, this is the product of such as and such company. So these are some of the popular logos shown here. When you look into the trademark, everything, in order to protect all this intellectual property, we need to pay some fees to the government. So when you look into the fees for this trademark, it comes around 4,500 if it is an individual or startup or a small enterprise, and if it is a large enterprise, if they are filing, it is around 90,000 rupees. So the validity of this patent is around 10 years, and it can be renewed indefinitely. So after 10 years, if you renew another 10 years, you will get, so on, you can keep on renewing. But if you forget to renew it after 10 years, someone else can take your trademark and they can market the product. So we should keep in mind, after every 10 years you should renew it properly. So next we have this industrial design. So any design can be patented. Whatever the design, if it has some sort of application, let it be a pen or let it be a dress, let it be a jewelry, let it be an article, let it be a furniture, whatever the case, if it is made into a product, those things can be protected by industry design. So this also has some fees, as well as the validity for this design is 10 years. It can be extended up to another 5 years. So the total years it can be protected is only for 15 years. After that it goes to the public domain or anyone can use the design. So next comes this copyright. Copyright is one of the large area, because most of the articles comes under this copyright. So what are the things comes under this copyright means? Books, music, manuscript, films, design, fashion designs, training manuals, software, literary work, performance, paintings. So all these things comes under copyright. So these things cannot be patented. These things can only be copyrighted. So when you look into the scenario of this computer science, we have the software programs. So when you look into India, these software programs can only be copyrighted and they cannot be patented. When they can be patented means, when the software is integrated with a hardware and it's created into a product, this can be patented. So when you are applying for copyright, it is classified into 6 classes. So that literature comes under part 1, artistic comes under part 3, then sound recording part 5, computer programs and tables comes under part 6. So when you look in the fees for this means, the fee range from 500 to 5,000, and the copyright term is for 60 years. Okay, this is the copyright protection that is followed in India. So next what we have is the geographical indicators. These geographical indicators are made to provide value to the products or articles that is made by some community or some place. So the validity for this graphical indicators is 10 years and can be renewed for another 10 years by paying the additional fees. For example, these are some of the examples that are given which has been obtained graphical indicators. This Coimbatore Rectangular is has obtained the GI tag. Then Tanjavur painting is there, Tanjavur art plate, temple jewelry of Nagarkoil, Tanjavur doll, Salem silk, and a tall coconut variety from Ithamoli. These are some of the products that are famous only because it is made in that place. So these people have received the geographical indicators. So all the other IPRs, like it may be copyright or let it be trademark or let it be patent, even an individual can obtain a protection. But in case of this geographical indicators, only a group of people or a society can obtain the geographical indicators. No individual or a single person can apply for this geographical indicators. That is the only difference of this geographical indicators from the other IPRs. Then we have this semiconductor integrated circuit design. This is the internals of a circuit, and the validity for this is 10 years. They give the protection for only for 10 years. You may ask why all these patents or IPRs or intellectual properties having a fixed period of validity or validity only for a fixed period. Why? Because this technology is constantly developing. All these products are provided protection for their technological aspects. So as the technology keeps on developing, what happens? New technology comes into force, and the old technologies we will not use. So old technology goes to obsolete. So that's the one of the main reason, because of the validity is only kept for a certain period of time. So when you look into the trademarks, that is just a logo. You will be using it for as long as the company is running. So that's the reason why this trademark can be renewed indefinitely. When you look into the semiconductor design or copyright, or when you look into the patent, they have a specified validity, because after a certain period of time those technology becomes obsolete, and there is no need for protecting it beyond that period. So next what we have is the trade secret. So trade secret is entirely different from the other intellectual property classes. Why? Because you don't apply protection to any government agency or any country to protect the secret. So what you have to do is you have to protect it within your company or within yourself, so that nobody is able to reproduce your product. So that's why its validity is given till the time is confidentially safeguarded. So if you are able to safeguard the secret for a very long period, you can safeguard it as long as. So if the technology comes outside, everyone can make it, and it comes to the public domain. So these are some of the products whose composition or how it is made is not known to the public so far. So we have this masala for this KFC, then WD-40 is there. So this is a product widely used to remove grease, or if a nut and bolt is tied together, if you spray this, it will come out. Then we have this Coca-Cola. All these formulations are not known to the public. So trade secret is, it has to be maintained by the company or the person who invented the formulation. Next, the protection comes for this plant varieties. So new varieties, then and there, agriculture universities or individual persons, they developed plant varieties. So when they develop a plant variety, what they will do is they will get protection for that plant variety. What happens is, when we develop a plant variety, some other country will take this and they will mass produce it, and they will sell that product. So it will cause an economic imbalance in our country. So what we do is, any new product we produce in terms of plants, that will be protected. So this is a table that is shown for plant varieties protection. You can see this website like plantauthority.gov.in. So in order to use, the plant should be, or the identified plant should be identified not older than 1 year and not less than 1 year and not older than 15 years. So this is a table. What happens is, here if you look, the plant is applied in the year, the protection is applied in the year 2019, and they got the protection in the year 2020, and the protection will stay forced till 2032. So next we are coming to the big class of this intellectual property, that is the patent. So any article which has an industry application, you can obtain the patent. So that's the main thing. So you don't have to look about anything. So if a new article or a new product, if you have found out, if it has an industry application, you can go for patent. So this is one of the patent that is obtained in the year 1989. So this is a fork. So the title what they have given is eating utensil. So this is the patent applied by Apple for iPhones. This is the first patent applied by Apple for their iPhones in the year 2012. Next, if you see how patents help countries, so there was a huge fight between companies in terms, when you look into the scooters, what happens is, in scooters the petrol tank will be below the seat. So TVS had an idea. So what they did is, they placed the petrol tank above the tail lamp so that it is outside the seat. So what happens is, without opening the seat itself, we can fuel the scooters. So this is the invention that is done by TVS Motors, and immediately what they did is, they went for the patent. So they received the patent in the year 2019. But during the same period also, there were some other countries, they also went for this patent. So there was a dispute between this TVS Motors and the other companies. So finally what happened is, this TVS Motors was able to prove that they were the first person to invent this technology. Now you see, the placement of the petrol tank, or the opening of the petrol tank, is the invention. It has an industrial use, or it has an advantage over the previous things. What's the advantage is, you don't have to open the seat, that is, you can just get down, open the tank, and you can fill the tank. So that's the only advantage here. So now TVS Motors is given protection for 20 years. Any company which has to place the petrol tank outside of the seat or behind the vehicle, means they have to pay royalty to this TVS Motors. So that's the scenario. So if you have a patent, you don't have to market the product, or you don't have to make the product. Some company or some person who is willing to make this product, what you can do is, you can license the technology to that company, and you can gain the royalty from that person. Next, another fight was there between Biocon and Milan. So this is, the fight is for the biggest market. The biggest market here is insulin market. So insulin is one of the biggest market in the world. So what they are predicting is, so it's an old scenario. So what they predicted is, the market will be around $70.6 billion. That is the biggest market share. So what is the fight here is, Biocon invented an insulin device for automatic injection of insulin. The same thing was also done by a company in the US, that is Milan. What happened is, Biocon is an Indian company, they fought with Milan, and they proved that we are the person who invented this device, and they got the protection. So now Biocon is having a monopoly in the market. No other companies can manufacture this device without getting license or permission or paying royalty to Biocon. So even without selling the product, Biocon will get benefited because they have the patent in their hand. So this is why industries, they rely mainly on product, they rely mainly on patents. So whatever the product they make, the first thing what they do is, they will go to protect their products by patents or copyrights, or by trademark, or any other trade secrets, any other means. So then only they will go to make their product. So this is what I told. Why companies? So they have the freedom to operate. They don't have to think whether other person will make the product. So there will be any competition in the market. So the companies don't have to think about anything. If they have the patent, they can simply go on, make the product, sell in the market. So they don't have to think about anything else if they have the patent rights in their hand. So next, patent. Patent is territory based protection. So if you have a patent in India, the product will have protection only in India. So what happens is, you have a product protection in India, some person can make the same product in China, and they can sell in US, no problems, because you have the protection only in India. If you want to have a protection in China, you have to apply patent again in China, and if you want to stop the selling in US also you have to get the patent. So then only you can stop others from selling in other markets. So if you have a protection in India, means you can sell the product or make the product only in India, and you can stop others from making and selling the product only in India. So patents are always territory based rights. So next thing is, the patent protection is granted only for a limited time. It is granted only for 20 years. So after 20 years, what happens is, it comes to the public domain. Now what happens? Anyone can make the same product and they can market, because your protection is only 20 years. Patents cannot be renewed. After 20 years, the technology comes to the public domain and anybody can make the product and they can sell the product. So before going into patents, we should know what can be patented and what cannot be patented. So that is first thing we should know before going for patents. So Indian patent law is there. So that is based on the Indian Patents Act, which is comes under year 1970. There were many amendments after that. So there is a section known as section 3 and 4 in the patent law. Section 3 and 4 clearly tells what cannot be patented. So first thing is, any law if you are proposing that contradicts the established laws of nature, it cannot be patented. If any product is made only for commercial exploitation, it may not be useful to the people. So if it is made only for commercial exploitation, that cannot be patented. Then the mere discovery of a scientific principle, initially I told, any product or process should have an industry application. If there is industry application, means only the product can be patented. So this is a scientific principle, mere discovery. So that cannot be patented. Then discovery of any living thing or discovery of non-living substances occurring in nature. Anything that occurs in nature, that cannot be patented. So patenting articles or the process should be man-made. Only man-made things can be patented. Anything that is present in the nature cannot be patented. Then new property or new use for a known substances. So for example, we have this paracetamol. Paracetamol is usually used for curing fever. So if somebody comes and tell paracetamol can be used for liver disease, and if he goes for a patent, it cannot be patented, because paracetamol is a known substance, but the application is new. That cannot be done. Next thing is, substance obtained by a mere mixture of two components. So for example, we have this paracetamol and there is an antibiotic is there. So if you mix two things and you are telling this can cure cold as well as fever, means no, that cannot be patented. You cannot just mix two things together and you can not apply for a patent. Next thing is, already existing things, what you are doing is, you are doing a mere arrangement or rearrangement or duplication of a known device. So what happens is, you have a mobile phone, camera will be in the back side. So you take it and put it in the front side, and if you go for patent, it cannot be patented, because that is just rearrangement of the components, but the use case is the same. So those things cannot be patented. Then method of agriculture. So if you develop a new method for agriculture or horticulture, that cannot be patented. A new method you are developing for surgical or medicinal or diagnostic process, that cannot be patented. If there is a plants and animals in whole or part, that cannot be patented. Mathematical or a business model or a computer program, if you are developed, that cannot be patented. But this mathematical or business model or computer program, that can be copyrighted. So this cannot be patented. This section 3K cannot be patented, but all the things that comes under this section 3K can be copyright protected. Then literary, drama, music or artistic work, that cannot be patented, but the same way this can also be copyrighted. Then method of performing or you have a method for playing a game like chess, there is a rules and regulations are there, that cannot be patented. Then presentation of information, that comes under the literary or writing, that cannot be patented. Integrated circuits cannot be patented. Then any traditional knowledge, so like 50-60 years back, some people were using some process, and now you are taking that, and if you are applying for patent, That is a traditional knowledge and it cannot be patented. Then any inventions related to atomic energy is not patentable as per Indian patent law. So these are the articles or process or things that cannot be patented. So what can be patented? A product or machine, a process or method, an article of manufacture, a composition of matter, and improvements of the above. So you have already a product or machine is there, maybe it produces more sound. Now you, what you did is you did some modifications to the machine and you reduced the sound, and it can be patented because there is an improvement, noise pollution you are reducing. So in that case you can go for patent. So these are the things that can be patented: a product or machine, a process, composition of matter which has some application, those things you can go for patent. So before going for a patent, what you should not do is you should not publish the work, you should not sell the product, you should not do any lectures or presentation. So if you have so confident that you have invented something or you have done any improvement to any product, so you should not publish the product. So what happens is when you submit the patent document to the patent office, what they do first is they will search the public domain whether a similar kind of thing is present in the world. They will not search only in India. If you apply to India also, they will search around the globe. So if anywhere or any article or any paper news or anything is present related to this your protection, means what they will do is they will simply tell it is an existing method, no novelty they will tell, and they will reject your application. So if you are so confident that you have invented a new product or a process, means don't go for publication, don't sell the product, don't do any lectures and presentation. You first tell the information to the patent office, then you do all these things. So whenever you submit a application to the patent office, three things they will look. So these three things are like a three-legged stool. If any one of the leg is not there, what happens is this stool will tip and it will fall. So what are the three things is they will look into the novelty, whether it is new, whether there is any inventive step. So you have done something new means also some innovation has to be there in the product, or there has to be in the any one of the steps you have used. Like old method for making copper, we will say for example some copper articles they are making, so they may heat it up to 2000 degrees Celsius. You have devised a new method where the copper article may be made at 1500 degrees Celsius. That is an innovation. So that should be there. These are the three components a patent examiner will always look into your product. So there should be a novelty, there should be an inventive step, there should be an industry application. If there you have a novelty is there, you have a product is there. If you are not able to tell what is the application for this product, means then also you will not get the patent. So all these three things should be there in your patent application. Only then you will get the patent granted. So if these three things are there, you can surely go for patent for your product or a process. So this is what we have seen. Before going for patent application, what you have to do is you have to search and find out whether your product or similar kind of product exists in the market. So in order to search that, what you can do is you can use these free databases. So what are the databases here is Google patent search is there. Like we have Google search for images, shopping we have, Google Scholar search is there. Same way Google is having a database for patent search. So INPASS is there. INPASS is the Indian Patent Advanced Search System. So what's the difference between this Google patents and INPASS is Google patents will show patents from some countries. There are more than 190 countries in the world. So all the countries have their own patent laws. All the people in that countries file the patents in their countries. So if you look into the Chinese patent, the language they use is Chinese language. Korean language they use. you will not get in Indian language, or in English you will not get that. So Google, what they do is they use their translate mechanism and they translate some of the patents, not all the patents. In past, what happens is only Indian patents you will get there. World intellectual property rights, if someone goes for uh, PCT based application or conventional application, that will come under this WIPO. So what's the main drawback of this using this free databases? You cannot search the worldwide data using these free databases. They are limited. For that, what is there are some paid databases are there. This Questel is there, Patbase is there, Derwent is there, Patseer is there, SciFounder is there. So what's the advantage of this paid databases is, if you look into this Questel, which I have used personally, so what's the advantage of this Questel is, they have the patents or updated patents of more than 150 countries. All the patents are translated to English. So you don't have to think about the language in which the patent is written. So you just have to go there, use the keywords, search and find out whether the technology is there or not, and you can go for directly, you can go for submitting a patent application. So that's the advantage of using this paid databases. But if you are not having this paid database also, Google patent is one of the best search engine that can be used for patent search. So after searching this, initially you have to think in your product whether novelty, inventive step and industry application is there. If three are there, you went for an search and you find out it is novel, it has an inventive step and it has an application, and nobody else has used your product or nobody else have made a similar product, then what you can do is you can go for patent application. Patent application can be done in different ways. First one is the provisional application. Provisional application is so what you do is you have an idea. So when you have an idea, what you think is, so in order to implement the idea, it will take around 6 months to 1 year, maybe 2 years also it may take. So what you are thinking is, while I work for the 6 months or 1 year time period, someone may parallelly somewhere else in the world may do a similar thing and they may go for the patent application. So what you can do is you can go for this provisional application. In the provisional application, what you tell is, I have an idea, I am going to do something like this. You don't have to tell about the outcome, and you send the application to the patent office. So they will give a time period of 12 months. What time period means? Within that 12 months period, what you have to do is you have to do the work, complete it, then you have to submit it to the patent office. So you have a priority over there. Even if you don't have the product, what you can do is you can go for a provisional application, and within 12 months period you can complete the work and you can submit to the patent office. Next comes this ordinary application. Ordinary application is the normal thing. Most of the people do this ordinary application. What they do is, you have the product, everything you have, all the results you have, you fill the application, you submit as a whole. So that is known as this ordinary application. So in case of provisional application, results will not be there. In case of the ordinary application, it is a whole document with all the contents fulfilled. Then comes this conventional application. So conventional application is like, if you want to submit this patent document to some other countries. So from India itself, you can submit the patent application to any other countries in the world. So that is known as this conventional application. So what happens is, you submitted the application in India, you get 12 months period so that you can submit the application to other countries. One more thing is there, that is known as the PCT application. What is the advantage of this PCT application is, initially it said like, in China if you want to apply a patent, the language should be Chinese. But if your application is submitted to this PCT route, means PCT applications are in English language. So 150 countries, more than 150 countries in the world have signed a treaty that in any country, if you are submitting to PCT, you can submit the application in English language. That's all. So the same document. So you don't have to rewrite the document for other country, or how they follow. You don't have to look into the rules and regulations. What you have to do is, if you are submitting for India, the same document you can submit it for the other countries. In 150 countries you can submit, provided you have to pay the necessary fees for each and every country. That is very, very important. Next comes the divisional application. Divisional application is initially you submitted one application, and the patent examiner finds that no, this cannot be a single application, this can be a two application. So he tells that, then what you do is you are dividing the application into two. So that is known as this division application. This comes mostly after the application. Then patent of addition. So you have one invention and you submitted to the patent office, and it is an granted one. You had some modification to the existing product, and you find out the modification is very good. So what you can do is this improvement also you can incorporate into the existing product, or the existing patent application, or the existing granted application. So that is known as this patent of addition. So what happens is, here you have a patent, you made a modification, you don't have to apply for another patent and wait for 12 months or 16 months or 18 months. You don't have to wait to get the grant. So you have a patent, add it to that, so you get the protection for everything as a whole. So your process can be, or your manufacturing process can be very fast. So next we will see, so far we have seen the types of application. Now we will see the contents of a patent. So contents of a patent means title should be there, field of invention should be there, background art should be there, objects of the invention, summary of the invention, drawing should be there, description of the drawing should be there, claims. You get protection only for the claims, not for the entire document. So in the entire document you keep all these things, but the claims are very, very important. So you have to tell for what are the things you have claimed, because I told initially, so you do some modification to an existing product, you can go for a patent. So you did only minor modification. So what you can do is, you can only modify the claims. So your protection you will get only for the claims. In case of a provisional specification, I told provisional is the one you submit when you don't have any results. So in that case, what you have to do is, if you have drawings, you can submit. Claims you will not have, because you haven't completed the work. So other things are necessary, like title should be there, field of invention should be there, background art should be there, summary should be there. With all these things, you can submit the provisional specification. So this is the entire process, flowchart of the patent process. So what you do is, you will file a provisional specification. So within 12 months time, what you will do, you will file a complete specification. Then if you are going for conventional application, and within 12 months you will go for the conventional, or what happens is, you can go directly for publication. So when you submit a patent to the patent office, what they do is, they have a patent journal. Every Friday they release the patent journal. So in that patent journal, what they do is, they will publish the abstract, title and the author names in the patent journal. So when they will do is, within 18 months they will do the publication. Once you submit, within 18 months they will do the submission. So that is a long period, around 1.5 years it takes. If you want to have an early publication, you pay some fees. So within 1 month they will publish your application. After publication, what you have to do is, you have to give a request for examination. So if you forget, or if you did not give a request for examination, they will not examine your application. So you have to keep in mind, once you submit, publication will happen, pay the necessary fees for this examination, then they will examine your product. After examination, what happens is, this examiner will submit the report to you. So they will give a time period, like 6 months, the time period they will give. You may ask for an extension for another 3 months. Once you submit the examination, FER is the first examination report. Once you submit the examination report, then they will decide whether they have to reject or grant the application. So even after first examination report submission, if the patent examiner finds that he need more details from you, he may call for a video conferencing. So during the video conferencing, you have to tell him or answer all the questions he is asking. So then they will go for the disposal or the grant. So this is the entire patent processing. So usually this entire process take around 2 to 5 years it takes. But now the scenario has changed a lot. So what's there is, if one of the applicant is a woman, or if the applicant is a startup company, the entire process, this entire process will get finished in 12-month time period. So that is known as this expedited examination. You can request for an expedited examination if one of the inventor or the applicant is a woman, or the applicant is a startup company. So this is the complete specification. Complete specification, everything should be there. So next we will see the fees for this patent application. So how much you have to spend for a patent application. So what happens is, in order to submit the patent, you need to pay 1600 rupees for the patent application. So that is for a number of pages, that is 30 pages, 1600. For every additional page you have to pay. If you have 31 pages means you will pay 160 rupees additional. So next thing is for the claims. If you pay 1600 rupees, you can submit a document with 30 pages and 10 claims. If more claims are there, for every claim you have to submit 320 rupees. So this is for a natural person or a startup or for a educational institution. So this charges for e-filing. So and if you go for a physical filing, the charges are different. There is an increased charges are there. So next one is, I told about this request for publication. Request for publication, you have to pay 2500 rupees. Then examination, that is early publication. So I told within 18 months period they will do the publication. If it doesn't, if you want an early publication, you can pay 2500, so that they will publish the document within 1 month time. Next, for request for examination, you have to pay another 4000 rupees. So the total amount or the government fees you have to pay for the patent office is around 8100 rupees. But if you are an educational institution, if your institution is supported by this Kapila scheme, the government will repay the fees what you pay to the government. So initially I showed some statistics, right, that India is lacking in the number of patent applications. So our government needs to boost the number of applications that is being submitted to the patent office. So they provide this Kapila scheme. So in this scheme, what are the amounts they will reimburse is, they will reimburse the application fees and the examination fees. Early publication fees, because anyhow after 18 months or before 18 months they will do the publication. So both the 1600 as well as 4600 rupees, 4000 rupees, that is 5600 rupees will be reimbursed if a college or a student or a faculty submits their patent application through this Kapila scheme. So if you look in, if you are able to create the document means you don't have to pay any fees if you are submitting to Kapila scheme. And the final thing is, like, you have obtained the patent, and if you want to keep the patent live, you need to pay some fees to the government. Even though the patent is having a lifetime of around 20 years, if the patent has to be live for that 20 years, you need to pay this fees. First 1 to 2 years you don't have to pay any fees. After grant, for 3 to 6 years you have to pay 800 per year. 7 to 10 years you have to pay 2400. 11 to 15 years 4800. 16 to 28,000. You may ask why I have to pay the fees. Because patent is made for industry application and to protect your product. So government is thinking that you have made a product and you are selling in the market and you are making huge profit out of your patents. So in order to give protection, and if you go for any legal help and to support you, government is charging this fees. So patent is mainly for industry application. So that's the reason this fees is there. So if you don't pay these fees, so what happens is your patent will be provided to the public domain and anyone can make that product. So that will happen. So far we have seen patents and we have seen the industry part of, or the industry application of the patents. But if you study these patents, there is also a huge career prospects is also there in this patents. So if you study the patent laws and you can write this patent agent examination which is conducted by the government of India, and if you pass the patent agent examination, what are the things you will get is you can get a job in a government agency, that is in the patent office you will get a job. You can become an Indian independent person and you can file these patents. Okay, you will become a patent agent, you will have a number, so directly you can submit the patent application. You can also work in private law firms, you can become a consultant, you can become an entrepreneur, even academic or research institutions. If you look into the Anna University, they have a separate patent office. 2 or 3 patent agents are working in that office. So such kind of job opportunities are there if you study this patent law and if you become a patent agent. So thank you for listening. So if you have any questions or discussions, now we will take. Any questions?